All right. Well, welcome everybody. This is very exciting. What a great day to talk about the United States Supreme Court. My name is Steve Schwinn. I teach constitutional law and human rights at the UIC Law School. And I have four dear friends and colleagues with me today. In the interest of time, I'm actually going to let them introduce themselves as we go. What we're going to do today is a pretty traditional kind of panel discussion of the Supreme Court's last term, with mention of the Supreme.
On the right, but it's on the way right. Yeah, that's the only location. I had a hard time finding it too, and then I found it and I'm like, all right, I'm going to take it off my comments. But
I think somebody is not muting themselves. If I'm going to ask everybody if they could mute their audio. That's awesome. Thank you very much. And so rather than taking time for me to introduce my friends and colleagues, I'm going to ask them to do that when they give their presentation. We're going to do this in a pretty traditional kind of style, where we've each agreed to talk about a couple of cases from the Supreme Court's last term, and mention a couple of cases or trends that we see coming down the pike for the Supreme Court's term this term, and then say anything else, I don't know, there might be other things going on at the court these days, maybe. So we might say other things about what's going on at the court or in politics general as well. Let me just start by saying this has been an extraordinary term. There were some blockbuster cases that I think we need to pay attention to, and some lesser well-known cases that I think we need to pay attention to as well. The big news from the Supreme Court, of course, is that Justice Ruth Bader Ginsburg passed a couple of weeks ago, leaving open a seat on the progressive wing of the court. President Trump and Senate Majority Leader Mitch McConnell moved very, very quickly to name a successor, and the Senate has now indicated that it's going to begin hearings for Judge Amy Coney Barrett from our own Seventh Circuit to replace Justice Ginsburg. Now, I just want to say really quickly, this would be a sea change in the United States Supreme Court. What it would mean is that one of the most progressive justices on the court, Justice Ruth Bader Ginsburg, is replaced by a fairly reliable conservative justice, Justice Amy Coney Barrett. And so whether you favor Justice Amy Coney Barrett or conservative jurisprudence, or whether you favor Justice Ruth Bader Ginsburg and a more progressive style of jurisprudence, I think there's no denying that this is going to be a huge change in the Supreme Court, and particularly in some cases that are already docketed for oral argument. Oral argument begins on Monday. Now, Judge Amy Coney Barrett won't be confirmed by Monday, but she very well could be confirmed by the court's November sitting. And we've got a couple of cases we need to keep an eye on then. So I just wanted to mention that by way of introduction. What I'm going to do now is turn this over to my dear friend, Professor McMurtry-Chubb, and she's going to get us going with a couple of cases that she's been watching.
Thank you, Professor Schwinn. So I'm Professor Teri McMurtry-Chubb. I'm a professor here at UIC Law, and everyone calls me Professor MC. I'm just going to jump right in here. So I'll be going over two cases from last year's term, and then two cases for the upcoming term. So the first case I'm going to talk about is Comcast Corporation v. National Association of African American Owned Media. A couple of disclaimers here. Professor Schwinn allowed us to pick the cases that were of interest to us. And when I read Supreme Court cases, I think I first read them as a historian. So these cases have particular interest to me because of their historical context. So ESN in this Comcast case is an African American owned television network operator, and it wanted to have Comcast carry its channels. So we all know how large Comcast is. Comcast refused to carry its channels, citing lack of demand, bandwidth constraints, and a preference for different programming. ESN alleged that Comcast violated 42 USC 1981, which guarantees all persons the same right to make and enforce contracts as is enjoyed by white citizens. So a little context here, Section 1981 originated in the Civil Rights Act of 1866, a year after the Civil War ended. And so so Comcast says, not so much. Race had to be a but-for factor in us denying the contract with you and denying you the ability to carry your channels. So the Ninth Circuit said, not so much. You just have to be able to plead facts, ESN, to show that race played some role. So the battle in the Supreme Court was over the point at which race factors into the decision-making process, or actually, according to Ruth Bader Ginsburg, which I'll get to in a minute. The majority opinion struggled with whether race had to be a but-for factor in the denial of Comcast to the African-American owned media request to carry its channels, or if it just had to be a motivating factor, basically at some point in the process of deciding whether or not to carry the channels, that Comcast just had to have some type of racial animus during the process. And the Supreme Court said that all federal cases have a presumptive but-for standard, that race has to be the but-for factor, and that the determination is made only at the point where the alleged violator is saying you get to enter into a contract with me or not. So again, some historical context here, enslaved persons could not consent to contract. So in many ways, in totality, the Section 1981 was meant to restore those rights. And so this age-old fight over, like, is this the but-for factor, or is it a motivating factor, and how do you show that, which has been raging violently since, I would dare say 1866, at least in the scholarship, 1978. But the court says clearly, no, this is a but-for factor. What I want to highlight here is Ruth Bader Ginsburg's, I'm sorry, let me be clear. The court said that race was not it wasn't the main determining factor for whether Comcast decided not to enter into a contract with ESN. So they lost, and the court vacated the opinion. So Ruth Bader Ginsburg's concurrence she agrees with the but-for standard, but she says, I don't quite understand at what point we're assessing this. Are we assessing this at the point where you decide to enter into the contract, or are we assessing this at the contract formation stage? So I just wanted to highlight that she, really wanted to talk about, so basically under her reasoning, at any point in time in the contract formation stage, you can be discriminatory. But at the final decision appears to be race neutral, you're okay. And so she kind of writes this opinion with that in mind. The other thing I wanted to highlight is that Erwin Chemerinsky, in his representation of the African-American owned media, kind of highlights that 1981 creates a color blindness standard, which is something that I take issue with, because as I mentioned, historically, this is a very color conscious statute. So I'll leave you with that for the Comcast case. The next case I want to highlight briefly is June Medical Services, LLC v. Russo. This was from the last term. This involved a Louisiana statute passed in June 2014 that required every physician who performs or induces an abortion to have active admitting privileges at a hospital that is located not further than 30 miles from the location where the abortion is performed or induced. So at the time where this is being litigated in the Louisiana courts, a nearly identical statute is being litigated in Texas, and the Supreme Court struck that down, saying that it placed an undue burden on a woman's access to abortion services. So in reaching its opinion, the court said, number one, the abortion statute, or abortion in Louisiana was safe, that there was no indication that a physician not having admitting privileges was going to endanger women. There was no significant health problem that the law helped to cure. There's no evidence that complications from abortion were treated improperly, and no credible evidence that negative outcomes would have been avoided but for the presence of admitting privileges. The thing I want to highlight about this opinion is that Justice Kavanaugh was a dissenter, and he said, we need more facts. The factual record's incomplete. And I find that interesting given that two clinics and two abortion providers did file a lawsuit alleging that this was going to place an undue burden on women. So there were already lots of facts in the record by the experts, and Justice Kavanaugh still said we need more facts. Two cases coming up in this most recent term. Again, my penchant for reading these as a historian. The Federal Republic of Germany v. Philipp one caught my eye because it's full of intrigue. It's full of Depression era ups and downs, post-World War II intrigue that kind of invokes like a spy drama, some of my favorite spy dramas. So what happened is in 1929, just before the global stock market crash, several Jewish art dealers in Germany purchased a collection of medieval reliquaries. During the global depression, because they're taking a hit, the dealers sold about half of the pieces and stored the remainder in the Netherlands. Now here's where it starts to get interesting. Nazi leaders negotiated with these Jewish art dealers to buy the remaining pieces, and the parties dispute whether this negotiation was made under coercive circumstances. I'm gonna leave it to you to decide whether Jewish art dealers during World War II were forced into giving Nazis their art. Maybe, maybe not, I don't know. After World War II, the collection was transferred to the Stiftung Preußischer Kulturbesitz, SPK, a German governmental institution that holds the cultural artifacts of former Prussia. And they've been on display in a German museum nearly continuously since then. So in 2014, the Jewish art dealers participated in non-binding arbitration before an advisory commission for the return of cultural property seized as a result of Nazi persecution, and they lost. They filed a lawsuit in the District of Columbia, basically saying that this property was taken from them in violation of international law. We're talking about the Foreign Sovereign Immunities Act. So you have Germany and SPK who are fighting these heirs of the German art dealers. And what's fascinating about this case is that it deals with two issues. One is the expropriation exception, which is this taking of this property under the Foreign Sovereign Immunities Act. And the question before the court is, does this exception provide jurisdiction over claims that a foreign sovereign has violated international human rights law when taking property from its own national within its borders? And then does the doctrine of international comity preclude the exercise of jurisdiction in this case? What's fascinating and what I'm looking for in the oral arguments and in the upcoming opinion primarily is how broad will this holding be? And will there be an opening in here for us to use this language in reparations arguments? The court talks about a genocidal taking as being a violation of international law. And again, the historian in me says, wasn't our taking of lands from Native Americans a genocidal taking? And weren't the taking of African bodies from the continent of Africa a genocidal taking as well? So we'll see what language the court gives us. And then last but not least is Jones v. Mississippi, which is going to be argued in this upcoming term. This involves a juvenile who was sentenced to death. Brett Jones was 15 years old when he stabbed his grandfather to death. He was convicted of murder in Mississippi and imposed a mandatory sentence of life imprisonment, which made him ineligible for parole. I'm sorry, he didn't get the death penalty. I'm jumping ahead. Life imprisonment. I equate the two the same because he was so young, 15 years old. He's now 29 years old. In a post-conviction relief proceeding, the Supreme Court ordered that he be resentenced in light of, to determine his parole eligibility. Subsequently, the Supreme Court came down with Miller v. Alabama, which held that a mandatory life in prison without the possibility of parole sentences for juveniles violated the 8th Amendment's prohibition on cruel and unusual punishments. And so the question before the court is, does the court have to find that a juvenile has permanent incorrigibility? And that language just kind of stuck out to me. Permanent incorrigibility to justify a sentence of life. Remember, he stabbed his grandfather at 15. He's now 29. He's never getting out of prison. And so this case, again, is fascinating to me because Brett Jones is white. He was 15 when he committed this murder, but we often see Black youth characterized as adults and sentenced the same. So Trayvon Martin, you might recall, was spoken of as a man. Tamir Rice, more apropos, spoken of as a man. And yet we have Brett Jones, who's 15, and we're dealing with whether his crimes reflect permanent incorrigibility. And so I find that he gets, this full and fair hearing where oftentimes youth of color don't. So with that, I'll hand it over to my colleague, Art Acevedo.
Hello, thank you, Professor McMurtry. My name is Professor Arthur Acevedo, and I too am a professor here at the law school. And I'll just jump right into to my portion of the presentation. I'm going to present 3 cases, and I'm going to start with the first one, which is Financial Oversight and Management Board for Puerto Rico versus Aurelis Investment Company. And the issue here centers on the appointments clause under the Constitution. So in 2016, in response to the fiscal crisis in Puerto Rico, Congress invoked its Article 4 power to make all needful rules and regulations respecting the territory belonging to the United States. Puerto Rico is the territory in this case at issue. And Congress passed the Puerto Rico Oversight, Management, and Economic Stability Act. And it's known as PROMESA, and in Spanish it means promise. They passed that statute, and that statute, that federal law, created a Financial Oversight and Management Board, and it provided that the president could appoint its 7 members without the advice and consent of the Senate. Now, we need to take into consideration the theory and the policy behind the Appointments Clause. And the Appointments Clause reflects an allocation of responsibility between the president and the Senate in cases involving the appointment to high federal office. And there's concerns about possible manipulation of appointments. The founders both concentrated the appointment power and distributed the appointment power, ensuring that primary responsibility for important nominations would fall on the president, while also ensuring the Senate's role of advice and consent power would provide the needed check on the presidential power. So the question before the court is whether this method of appointment, meaning without the advice and consent of Senate, is legitimate. So factually, what happened was, pursuant to this federal statute, President Obama created a 7-member board, and this board was tasked with the responsibility of bringing financial stability back to Puerto Rico. But when the board began proceedings in federal court to restructure Puerto Rico's massive debt, a hedge fund that had invested in distressed Puerto Rico bonds and a local labor union went to court to challenge the method by which the board members had been appointed. They argued that under the Constitution's Appointments Clause, that the board members should have been nominated by the president and confirmed by the Senate. That didn't happen in this case. And because they were not, they challenged this action, and they brought this lawsuit. So the Supreme Court took this case, examined it, and unanimously rejected the argument presented by the challengers that there should have been an appointment made pursuant to this Appointments Clause. And Justice Breyer, writing for a unanimous court here, agreed that the Appointments Clause applies to all officers of the United States, including high-level officers whose duties related to Puerto Rico. And then the court added that the clause's use of the phrase, quote, all of the United States, indicates that the drafters of the Constitution intended to distinguish between federal officials on one hand and officials exercising state or local power on the other. Moreover, as the court notes, 2 provisions of the Constitution give Congress authority to legislate for the District of Columbia and U.S. territories. And the court cites as support for this rationale the text and the structure of the Constitution and the history that indicates that when Congress has created local offices using this power, those officials have been regarded as exercising local government power rather than federal power. And we see this tension a lot between the exercise of federal power and government power. Indeed, that the court had observed here that, quote, to read appointments clause constraints as binding Puerto Rican officials with primarily local duties would wreak havoc with Puerto Rico's democratic methods for selecting many of its officials. And the court concluded also that the appointments clause does not restrict the appointment of local officers that Congress vests with primarily local duties. Justice Sonia Sotomayor also wrote a concurrence in this opinion, and she also agreed with the court's judgment, but she wrote separately to emphasize that the extent to which Puerto Rico, like a state, is an autonomous political entity. And she wanted to highlight this point. Despite the autonomous status, Justice Sotomayor continues writing, and she says that the board has, quote, wide-ranging veto-free authority over Puerto Rico, with Puerto Rico's governor limited to a non-voting role on this board. And as a result, she concludes that the court's ruling seems anomalous, that the board exists in this, quote, twilight zone of accountability, which is neither selected by the Puerto Rico itself nor subject to the strictures of the appointments clause. And the end result of this case is that it was sent back to the lower court for further proceedings, but it's clearly a victory for the board here and a defeat for the challengers, who were the hedge fund and the labor union. My next case is Thole versus United States. And this is a case that deals with pension plans, specifically a defined benefit pension plan. And as I go through the explanation, I'm going to explain the distinction between a defined benefit plan and a defined contribution plan. But the issue, just so that we're all centered, the issue here is whether the participants here have standing to bring a lawsuit. And this was a much closer case. This was a 5-4 decision, and the Supreme Court held that these participants and the beneficiaries in this defined benefit plan do not have standing to assert fiduciary breach claims in the absence of a catastrophic plan or sponsor failure. And factually, this is what happened, is we have the plaintiffs, James Thole and Sherry Smith, who are retired participants in this pension plan. They are retired participants in the U.S. Bank's defined benefit retirement plan. And again, I want to emphasize defined benefit in contrast to defined contribution. And this defined benefit retirement plan guarantees them a fixed payment each month, regardless of the plan's value or its fiduciary's good or bad investment decisions. And the payment stays level. So both have paid all of their monthly pension benefits so far and are legally and contractually entitled to those payments for the rest of their lives. Nevertheless, they proceed and they file a class action lawsuit against U.S. Bank under ERISA, alleging that the defendants, the U.S. Bank, had violated ERISA's duties of loyalty and prudence. Why? Because they poorly invested the assets, and as a result, there was approximately $750 million in losses due to this mismanagement. They filed the lawsuit, and ultimately worked its way through the district court. It works its way up to the U.S. Court of Appeals for the 8th Circuit, and the U.S. Court of Appeals held that Thole and Smith lacked standing because they had received all of the benefits to which they were entitled. So this theory of standing originates in Article 3's case or controversy requirement. And the Supreme Court interprets standing to require that a plaintiff seeking to access the federal courts suffer a direct or imminent injury. There are 3 requirements for constitutional standing, and this direct or imminent injury is one of those 3. And that's the prong that's at issue here. Justice Kavanaugh, who was writing for the majority, and he was joined by the Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch, he agreed with the Court of Appeals approach that Thole and Smith lacked Article III standing. The majority held that Thole and Smith do not have a, quote, sufficient stake in the outcome of the lawsuit because win or lose, they will receive the same amount of monthly pension benefits from the plan. And their reasoning goes as follows. First, they determined that they distinguished a defined benefit plan, such as the one that's at issue here, from a defined contribution plan. In a defined contribution plan, the participants contribute money into a plan and they're entitled to, it's their money plus any matching contributions by the employer. In contrast, in a defined benefit plan, participants do not contribute, the employer contributes, and then a payout is made according to a predetermined formula between the employer and the employee. And then the majority writes here that the rights in a defined benefit plan are more in the nature of a contract right than the trust-based equitable or property rights that flow from a defined contribution plan. And therefore, the court reasoned that Thole and Smith did not have any equitable or property interests in the plan. And then a second rationale that the court adopted was that neither Thole nor Smith received an assignment from any of the plan's potential fiduciary plans, and therefore they could not act as representatives of the plan. And then third, Thole and Smith had pointed to language in ERISA that explicitly provides a cause of action for participants and beneficiaries, in addition to providing for a cause of action to the Secretary of Labor or to a fiduciary to bring a claim for a fiduciary breach. And here, the majority looked to precedent establishing that a grant of a statutory right is not sufficient to establish Article III standing. A concrete injury is required, again, otherwise known as constitutional standing, which the elements include injury, traceability, and redressability. And the majority added that because Thole and Smith have not suffered any financial injury, they do not meet that requirement of the injury prong. However, the majority did recognize that the current case does not involve an alleged breach of duty to provide plan information, thereby leaving open the possibility for a cause of action based upon a failure to comply with plan information requirements. Justice Sotomayor authored a dissent, and she was joined by Justice Ginsburg, Justice Breyer, and Justice Elena Kagan. And she took issue with the position of a concrete injury proposed by the majority. And she specifically challenged the implication, at least, that one has to suffer a direct and immediate financial loss. In dissent, she agreed with the distinction of the rights of the defined benefit plan participant and beneficiaries are the rights of those entitled to benefit from defined contribution plans as well. She mentioned, or she writes that ERISA requires that the plan assets be held in trust, and that if as a majority holds, plan participants and beneficiaries are not entitled to the equitable title in the plan assets, then no one would hold that title. And then she writes that this reasoning by the majority is unpersuasive. And then she also points out that it is well established in trust law that trust beneficiaries have standing to bring claims for a breach of loyalty, even in the absence of any loss to the trust. Further, monetary injury is not required for standing. And then finally, I think this is another important point in her dissent. She argues that Thole and Smith have standing as representatives of the plan because unlike a corporation which can bring a claim on its own, a pension plan cannot act on its own, and therefore it requires a person to act on its behalf. Thole is a really important decision because it illustrates this tension that we often see in a lot of ERISA cases. And the dissent emphasizes the protective purposes of the statute and worries that the risk of fiduciary misbehavior could imperil the benefits of plan participants throughout the country. Then the last case that I'm going to talk about is Rodriguez versus the FDIC, and this is a tax refund case. But more than a tax refund case, this is really a case about federal common law. And so what happened here was the IRS allows an affiliated group of companies to file a consolidated income tax return. And the IRS issues any refund that arises out of this group of companies to a single designated agent. And the tax regulations themselves say very little about how the group members should then distribute the refund among themselves. If a dispute arises and the members have no tax allocation agreement in place, the federal courts normally turn to state law to resolve the distribution question. So who is entitled to this refund? Some courts, however, have crafted their own federal common law rule known as the Bob Richards rule. And this rule initially provided that in the absence of an agreement, a refund belongs to the group member responsible for the losses that led to it. So the narrow question that the Supreme Court examined is whether state law or federal common law determines the ownership of a federal tax refund paid to a parent company, but arising out of the loss or the income generated by its subsidiary. And factually, what had happened here was that in 2011, a Colorado-based bank holding company named United Western Bancorp Incorporated filed a consolidated return on behalf of itself and its federally insured subsidiary. There was a claim for $4 million in refund on account of losses generated by the subsidiary. By the time the check had arrived a couple years later, the federal regulators had shut down the bank subsidiary, and the parent bank itself filed for bankruptcy. So the issue becomes who owns this refund check? Because the bankruptcy estate is seeking to claim ownership of the refund check, $4 million, and the FDIC as the insurance corporation is seeking to claim ownership of the $4 million check as well. So the 10th Circuit initially sides with the FDIC, and the 10th Circuit said that the federal common law provides a framework for resolving this issue. Well, the justices granted cert with this objective in mind. As Justice Gorsuch writes in the opinion, he says, we took this case to decide Bob Richards' fate, meaning this common law case. And the court notes that the cases in which federal courts may engage in common lawmaking are few and far between. And Gorsuch writes, adding that this is one of the cases that lie between. Outside of areas such as admiralty law, in which the Congress has authorized judges to craft federal common law, the Supreme Court has repeatedly said that uniquely federal interests must be at stake for federal common lawmaking to be legitimate. And then with that as a result, Gorsuch, in a short 6 pages, pretty much limits the application, at least of this federal common law rule of the Bob Richards case in this particular matter. So what is the implication of this case? Well, federal common law is common throughout a number of tax cases. For example, we have the business purpose rule, we have the substance over form rule, and there are a number of other rules that the courts have used through the years. And it really draws into question what is the future of these federal common law rules, not just in tax law, but in other areas of the law as well. All right, I'll stop there, and I will turn it over to my colleague, Professor Ricardo.
Thanks, Professor Acevedo. I am just going to, my name is Kim Ricardo. I direct our lawyering skills program here, and I'm also teaching criminal procedure as well as LS1 this semester. So I kind of just wanted to start my presentation by showing you a few photos of Justice Ginsburg. We've all already mentioned a few words about Justice Ginsburg, and I'm sure we'll have an opportunity later to further address her legacy on the court. But I wanted to share with you, just before I began my presentation, a few of my favorite photos of her. I went to the University of Hawaii Law School, And it has a really outstanding jurist in residence program. As you might imagine, in the winter months in DC, it gets pretty cold. And so US Supreme Court justices and federal district and appellate court judges are always really excited to visit Honolulu. So I had the opportunity while I was a clerk in 2004 to meet Justice Ginsburg at the Hawaii Supreme Court when she appeared in front of the Hawaii Bar Association to give a talk. And so that's me pictured with her on the left. And a few years ago for Halloween, I put on my notorious RBG t-shirt and came up with this character. That's me as Ruth Bader Ginsburg. So I wanted to share those with you just as a start, as just a sort of my own personal tribute to Justice Ginsburg. So the two cases that I'm going to be discussing today are two criminal law, criminal procedure cases. And I see, you know, some of my criminal law, procedure students out there. So shout out to you all. Thanks for coming. So the first of the two cases that I'm going to be discussing, US v. Collins, is actually representative of three consolidated cases. In each of these three cases, the male service member was subject to court-martial and then convicted of raping a female service member. In each case, the military prosecuting authority did not initiate criminal proceedings until many years after the crimes were originally committed. In the case of Briggs, that was 8 years afterwards. In Collins, that was 16, and in Daniels, 17 years afterwards. Now, it's important to note that none of these defendants actually raised a statute of limitations defense at the times of their courts-martial. They all ended up appealing to the US Court of Appeal for the Armed Forces. And only at this appeal was it that the defendants first raised the statute of limitations argument. The CAAF declared that the statute upon which the military prosecutors had proceeded was unconstitutional. So these three cases raised first a statutory interpretation issue and potentially a constitutional issue because of the Eighth Amendment. So in order to understand what's going on in Collins and the rest of these cases, first you should know that in a 2008 case called Kennedy v. Louisiana, in a majority opinion written by Justice Kennedy and also joined by Justice Ginsburg, the court ruled that the Eighth Amendment bars the death penalty for all non-homicide cases. So there's two interesting side notes to Kennedy that are relevant to understanding the constitutional issue potentially at stake in Collins. First, the Kennedy court cited Professor Corey Young's 2004 Law Review article in its reasoning. Justice Kennedy cited this article for the proposition that by imposing the death penalty for child rapists, the 6 states that still imposed the penalty back in 2008 were essentially incentivizing the rapist to kill the child to eliminate all evidence of the crime. Now, I raise this because, of course, Professor Young taught at UIC Law at the time of the decision. Second interesting point, after the court's initial opinion was released, a military blogger noted that the opinion contained a factual error. Justice Kennedy's opinion stated that child rape was a capital offense only in 6 states. The fact that no federal jurisdictions authorized the death penalty for the offense was a key part of Kennedy's argument that there was broad consensus in the United States for his holding. The blogger noted that Congress had actually revised the Uniform Code of Military Justice just 2 years earlier to add child rape to the list of capital offenses. Now, to Justice Kennedy's credit, none of the briefs filed at the court had contained this key information. And after a couple months and additional briefing, the court eventually voted 7-2 not to revisit its decision. And that 7 included the 5 justices originally in Kennedy's majority, plus the addition of Chief Justice Roberts and Justice Scalia. So there's a statutory question in Collins, right? And that is, which subsection of the UCMJ, the Uniform Code of Military Justice of Section 843 applies. Is it subsection A, which states that any military offense punishable by death may be tried and punished at any time without limitation? Or is it subsection B, which creates a 5-year statute of limitation for other military offenses, right? The government, of course, argues that it's subsection A because military rape under the UCMJ is punishable by death. The defendants argue that it's B because Kennedy v. Louisiana means that the 8th Amendment prohibits capital punishment in non-homicide rapes. That is sort of a quick and dirty summary of the Collins and consolidated cases. Now I'm going to move on to Torres v. Madrid. And this, criminal procedure students, this case addresses the threshold question under 4th Amendment violation analysis. And that is, I want you to say it with me, whether, well, in this case, that threshold question in particular is whether an unsuccessful attempt to detain a suspect by the use of physical force is a seizure, right? In other words, we're just asking the preliminary question. Is the police action here, in fact, a seizure under the 4th Amendment? Torres v. Madrid is really important because the court's decision here would resolve a circuit split. The 10th Circuit and the DC Circuit both say that the attempt to detain must be successful in order for there to be a 4th Amendment seizure. The 8th, 9th, and 11th circuits have held otherwise. So now just some facts to sort of give us a little bit more context into the Torres case. The case arises out of events in 2014. 2 Arizona State police officers arrived at a housing complex to serve an arrest warrant in the early hours of the morning. It's still dark. Roxanne Torres, who's the plaintiff in the Section 1983 case, was in the parking lot of that housing complex with her in her car with the engine running. The police parked their car near hers, and even though she was not the person named in the arrest warrant, the police approached her car wearing dark tactical clothing with guns drawn and started yelling at her and trying to open her doors. Torres thought that they were carjackers and started to drive off. In response, the police opened fire after her with 13 bullets, 2 that hit Torres in the back. Nevertheless, after being shot, she managed to flee the scene. Now, it's pretty settled law that when a police officer uses deadly force to apprehend a suspect, there's no question that a seizure has taken place. However, the twist in the facts here is because Torres actually managed to flee the scene, the question raised is the threshold one, whether the seizure, whether this action was a seizure in the first place. Now, it is a significant legal question under the 4th Amendment, but I think in the larger context of social and historical events, it's a case that forces the court to confront issues of police violence and use of deadly force against civilians. Now, both Collins and Torres were originally scheduled for oral arguments back in March before the pandemic. That's important to note because these were already on the court's docket and will be heard this month. But earlier this summer, after George Floyd was killed by police, after all of the mass protests against police violence and police killing and in favor of Black Lives Matter, the court denied cert in 8 separate cases that would have put the doctrine of qualified immunity on the docket. Now, Torres is a 1983 case, but we won't probably get to that qualified immunity issue. Now, I want to show you just one last, here we go, one last slide here. It is a quote from Justice Sonia Sotomayor's dissenting opinion in a 2018 qualified immunity case called Casella v. Hughes. I'll let you read that, and I will just say that Torres is an interesting case to follow, in particular for my criminal procedure students, because it illustrates the difficulty that 1983 plaintiffs have in establishing a prima facie case. Because even if she's able to establish that her Fourth Amendment rights were implicated by getting shot at by police, a court would still have to determine whether that use of deadly force was reasonable. That just gets us to the constitutional violation question. And then she would have to get, in order for her case to be heard at a trial, she would have to get past the qualified immunity doctrine that, of course, is in the news a lot right now. So thank you, and I will now pass it on to my colleague, Professor Mark Wojcik.
Hi, thank you, Kim. Let me pull up a slide for you as well. I'm talking about one of the big cases from last term, Bostock versus Clayton County, and give you a preview of Fulton versus City of Philadelphia case that will come up right after Election Day. These are the Title VII cases on sexual orientation and gender identity. First, a little bit of context. There's no US federal statute that expressly protects sexual orientation or gender identity. They're not listed as such as protected categories. There is proposed legislation, the Equality Act, that would replace sex with sex and defining as in sexual orientation and gender identity. And this passed the House of Representatives in May of 2019, but it stalled in the Senate. Maybe we don't need that legislation anymore because of the Bostock decision. Title VII of the Civil Rights Act in its text says that it prohibits employment discrimination because of any individual's race, color, religion, sex, or national origin. And this applies to businesses with 15 or more employees. I just want to take a moment to note that there is state legislation, state and local legislation, that would apply sexual orientation discrimination to even a company with a single employee. But on the federal level, 15 or more employees. So under Title VII, the plaintiff must show that there was employment discrimination based on a motivating factor, and it doesn't have to be the only factor. Congress did not say only because of race or only because of gender or primarily because of. So this means that even if the employer has another good reason for firing someone, the employer cannot avoid liability for citing that other factor. So this continues the march of this gay rights struggle. It started with the Stonewall, well, started before Stonewall, but manifests itself in Stonewall, the police raids there that we celebrate with the annual parades now. And when we do such things, then they'll come back. But this is the mixture of agitation, litigation, legislation, education. And we finally found in this past year, 3 combined cases in one opinion. There was a split among the federal circuits about whether sex covered sexual orientation and gender identity. And we got this answer on June 15th, majority opinion by Justice Gorsuch with Justices Alito, Thomas, and Kavanaugh dissenting. Let's meet the plaintiffs. Gerald Bostock worked for Clayton County, Georgia as a child welfare advocate. He did that for 10 years. He was very good at the job. He got lots of awards and recognition, but he joined a gay softball league and was fired for conduct unbecoming a county employee. So if any of you are thinking of joining a softball league, I think you can now do it because the Supreme Court said you can do this. Donald Zarda in the second case, Altitude Express versus Zarda. He was a skydiving instructor. He was taking a woman up for skydiving, and she was objecting to being strapped to him. And he said, basically, I'm paraphrasing, "Don't worry, honey, I'm gay." And days later, he was fired. Unfortunately, he died in a base jumping accident in Switzerland at the age of 44, and didn't live to see the Supreme Court decision in his case. And RG and GR Harris Funeral Homes involved Amy Stevens, who presented as a male when she was first hired, but later began treatments for despair and loneliness and began living as a woman. She told her employer that she was going to live and work full-time as a woman. Funeral home said, "This is not going to work out." She died on May 12, 2020, as a result of kidney failure exacerbated by the lack of care, medical care, lack of access to medical care because she had been fired from her job. So she also didn't live to see the rulings. There was a split in the decision. Bostock said it didn't, Title VII does not prohibit employers. Zarda and Stevens says it did. That's the split. And it goes to the US Supreme Court. What happened there? Justice Scalia had died in 2016 and President Obama had nominated Judge Merrick Garland to fill his seat. And after 293 days, that nomination expired. President Trump nominated Judge Neil Gorsuch to fill Scalia's seat. And the important thing here is that Justice Gorsuch voted the way that Garland would have voted in this case. Gorsuch was looking at the plain language of the statute, and Garland would have as well, to find that it's covered. Here's what the court says. I have to just one thing on my screen. Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex is a necessary and undisguisable role in the decision of what Title VII, exactly what Title VII forbids. So, looking at the plain language, sex was the reason why these LGBT persons were fired. Now, if we had looked at the legislative history of Title VII, this is really funny, actually. When in 1964, when the Civil Rights Act was introduced, a Southern congressman tried to thwart the legislation by adding sex to race. He said, "Oh, you want to protect race? Well, let's throw sex in there, protect all women, and then it'll be crazy." And he expected that adding that language would have defeated the bill, but what it did is that it threw sex into it. So if we were going on legislative intent, that it would be crazy to try and interpret it on that. It wasn't the intention of the proponent to include sex or gender discrimination. It was the intention of the proponent to defeat race discrimination. So here's our holding. And this is huge. An employer who fires someone just for being gay or transgender violates Title VII of the Civil Rights Act. This is a major, major holding, a landmark decision, a landmark victory for LGBT persons in the United States. Title VII also prohibits retaliation, discrimination by association. So you don't have to be LGBT yourself. You can just be standing up for the rights of LGBT persons. And it prohibits harassment that is severe, pervasive in a work environment. What should employers do? If any of you are working for employers, it's time to check the handbooks and websites to be sure that the non-discrimination provisions of those documents and websites include sexual orientation and gender identity. You should have employers be able to allow employees to update their employment records with their name and gender, update forms and form letters. Be sure that you avoid sexist language. Instead of mother, father, you put person one, person two, for example. Check the insurance coverage on transgender healthcare and have either no dress code or a neutral dress code. There's been some question about whether Bostock will apply to non-binary people, and the answer I think is pretty clear, yes. Someone who faces discrimination because they're not traditionally male or not traditionally female is discriminated because of their sex, their failure to be male or female. So I think that non-binary people are clearly covered under the decision, even though the decision had nothing to say about that directly. In the coming term, we're going to see a case, Fulton versus City of Philadelphia. This is the religious exception to non-discrimination. Now, it's going to be heard on the morning of November 4th, while ballots are still being counted. I can't imagine that we'll have a winner declared by the morning of November 4th. Maybe we will, but this is the day after Election Day, and this is a day when we will severely miss the presence of Justice Ginsburg. The question that the court will consider that day is whether the government violates the First Amendment by conditioning a religious agency's ability to participate in foster care system by requiring that foster care system to comply with non-discrimination. So the city of Philadelphia has an adoption service, but it can't discriminate against gay and lesbian persons. A Catholic adoption service wants to discriminate against gay and lesbian persons and unmarried persons, unmarried couples. And that's the question that they're going to consider. This implicates the Religious Freedom Restoration Act that prohibits the government from substantially burdening the person's free exercise of religion. And I'm going to toss the discussion to Professor Schwinn for a moment so that he can give some predictions and more context about the Clayton County case. Steve, you're muted.
Hey, thanks so much, Professor Wojcik. What a great presentation, such a critical case. And I think it underscores that, when we start to think about justices as conservative justices versus progressive justices, sometimes they surprise us. And I think this case is a healthy reminder of that, but it's also a significant step forward, as Professor Wojcik said, in civil rights protection, the Bostock case. The Fulton case is, I think, something to keep our eye on. We've seen a long trend on this court where the Supreme Court has been, we think about the division, what we call the division between church and state, a kind of wall between church and state. Well, this court has been on a long trend of knocking down that wall and allowing religion and state to intermix in ways that are sometimes quite surprising. So we had a case on the docket this past term, for example, dealing with a so-called no aid provision in the Montana Constitution that said that state aid can't be used for religious purposes. Well, the state had a scholarship program that gave a tax credit to individuals who contributed to this scholarship program, and then parents could use the scholarship to send their children to private schools. But because of the state aid provision in the Montana Constitution, the rule was that parents couldn't use it to send their children to private religious schools. Well, the religious schools and the parents who wanted to send their children to religious schools, they argued that that was a violation of free exercise. They took the case to the Supreme Court, and the Supreme Court agreed. Now, that case follows on an earlier case a couple of terms ago dealing with a grant program that operated in a similar kind of way. Now, with the Fulton case coming to the court next term, I think we're going to see the court come full circle on free exercise claims of this type, and particularly with the addition of Judge Amy Coney Barrett and the replacement of Judge Amy Coney Barrett for Ruth Bader Ginsburg. I think we're going to see the court really accelerate this trend, knocking down the wall between church and state. I think this is a really important thing to keep our eye on, whatever we think about free exercise and the Establishment Clause under the First Amendment. This is a really important trend that we're seeing in the court's jurisprudence. I want to say a couple of words about just a couple of other cases, and I'll keep it brief because I really do want to hear what you all have to say. There's already been a question and comment about qualified immunity that I hope we can get to. What I want to talk about is the Trump tax cases, just very briefly, and the DACA rescission case, very briefly. So first, the Trump tax cases. You'll remember there were two of these. One came when congressional committees, in particular 3 House committees, subpoenaed the tax and financial records of the Trump corporations from the accountants and banks of President Trump, not from the Trump family or the organizations themselves, but rather from the banks. Well, at that point, President Trump stepped in and sued the banks and said, we don't want the banks to turn this over to Congress. President Trump's argument was jaw-dropping. What he said was that Congress lacks legitimate legislative authority to subpoena these documents. Now, I'll say that again. Congress lacks legitimate legislative authority. What that does is put the hands of congressional investigatory power in the hands of the White House, right? I mean, that's astonishing. It would have marked, if the court adopted that theory, it would have marked a significant shift in the separation of powers in our system, a huge sort of sucking sound from the congressional end of Pennsylvania Avenue to the White House, and completely empowered the president. The Supreme Court rejected the claim, and it did it flatly. It was a 7-2 ruling. What the Supreme Court said was Congress might have a legitimate legislative purpose here, but Congress needs to pay attention to the sort of special features of our separation of powers system and be particularly concerned when it's subpoenaing the private information of the president, him or herself. And so the court ultimately kicked the case back to kind of work out whether Congress had done that. Now, in the meantime, we know that the New York Times has published so much of President Trump's tax records and financial information that doesn't totally moot out these cases, but it does give us some additional information and shed some light on the political meaning of this case. Now, the other case was came out of a grand jury in New York. A state grand jury was convened to investigate the goings-on at the Trump administration and had subpoenaed information, again, not from the Trump organization itself, but rather from President Trump's accountants and Deutsche Bank, Capital One, his banks. President Trump then stepped in exactly the same way and sued the banks, trying to get the court to stop them from turning the information over to the state grand jury. Now here, President Trump asserted an equally breathtaking claim, but of a different sort. What President Trump said is that the president is categorically, always, anytime immune from state criminal processes. So you remember the old line that the president could shoot somebody on Fifth Avenue, right? And his supporters wouldn't care. Well, here, what he's saying is the president could shoot somebody on Fifth Avenue and the state criminal justice system could do nothing about it, right? I mean, this was a breathtaking claim. He rooted it in Article 2 of the Constitution and federalism principles. What he said was to allow this kind of thing to go forward would be to invite all state district attorneys to bring all manner of claims against the president and basically hassle the president in a way that he wouldn't be able to do his Article 2 job under the Constitution. Well, the court again completely just categorically denied this claim of the president and said, look, there are features of the jury system, the criminal system on the state level that are designed to protect the president. And we're more than happy to let those features do their work. We don't need to go so far as to say that the president is categorically immune from criminal process. Instead, what we can say is that the criminal process can take care of itself. If the president feels like the criminal process is hassling him, he can raise those claims below. And so again, kick the case back for further proceedings, and we've kind of seen where that's gone. The Trump administration has proved, let's say, uniquely adept at dragging its feet through litigation and essentially running the clock, and we're seeing that trend in this case as well. Just a real quick beat on the DACA rescission case. You'll remember that President Obama implemented the Deferred Action for Childhood Arrivals program, the DACA program, and a companion program called DAPA for parents of childhood arrivals. The Trump administration sought to rescind that program, and the decision is technically somewhat complicated and deals with areas of administrative law, but I'll try to make it as simple as possible. What the Supreme Court said was the Trump administration's effort at rescinding the DACA program was arbitrary and capricious and therefore unlawful under the Administrative Procedure Act because it wasn't based on reasoning that sufficiently justified the move. Okay, so whatever you think about the DACA program in the first place, the court said, whether it was legal or illegal in the first place, the Trump administration in rescinding that program acted unlawfully because it didn't satisfactorily explain its decision and take account of the different things that it needed to take account of in order to make that kind of administrative law move. Now, this is a trend that we've seen in other cases at the court as well, holding the Trump administration's feet to the fire under the Administrative Procedure Act. And, you know, it's an important separation of powers idea, and therefore an important constitutional and civics idea in our system. But it also underscores, and for the students out there, the importance of administrative law. So many of us practice administrative law full time or at some point during our career, and we now have a string of opinions coming out of the Supreme Court dealing with things that the Trump administration has tried to do that hinge on administrative law. So I'll just make a plea to my own students. Again, look for administrative law offerings in your studies. I think they're going to serve you well. Now, I'm going to stop there. We have some questions coming in through the chat. I see one directed at Professor Wojcik, and it's to everybody. I'll just ask Professor Wojcik, do you want to pick it up and answer that question?
I don't want to answer this question because I'm afraid of the answer. Mr. Eisner, thanks for the question. Do I believe that the court will use Fulton to overrule Smith and head back to a strict scrutiny test for First Amendment claims? There's a couple of different ways that the court could go on November 4th, or in the decision that comes from November 4th. They could decide to re-argue it. They could, when a ninth justice is appointed, or if there's one by then. But it's certainly possible that they might use that to overrule the Smith and to go back to a standard where any rational, crazy notion of why we can discriminate against LGBT persons is legitimate. I think Steve, you have some deeper thoughts on this.
Well, it's giving me way too much credit, Professor Wojcik. I'm not sure my thoughts are deep at all, but I will say that I do expect the Supreme Court, especially with Justice Amy Coney Barrett, to revise and revisit Smith. And that question is squarely before the court in this case. As we know, the Smith test says that a neutral government action broadly applicable across the board that happens to have an incidental effect on religion is subject only to rational basis review by the courts, which means that most of those things are upheld. The other way to look at it would be if those kinds of actions were subject to a higher level of scrutiny, most likely strict scrutiny. And that's exactly what the Religious Freedom Restoration Act does at the federal level, but not at the state level. We see a number of states have sort of mini RFRAs that do that at the state level under state constitutional provisions. And they all have a kind of trip mechanism in them. The government action has to substantially burden religion in the first place. And so that can, I say this cautiously, that trip mechanism can operate as a safeguard against an automatic application of strict scrutiny, which would mean that so many of these neutral government actions would fail. And, you know, we've seen so much litigation in this area, we can use our imagination to think about the number and types of different government actions that would fail under heightened review under the Free Exercise Clause. It's pretty breathtaking, but I do expect that the court's going to move in this direction. It was a terrific question. Thank you. So there was another question on qualified immunity that came in earlier when Professor Ricardo was talking. I wonder if I can loop back and ask any of my friends, do you want to, would you like to address qualified immunity?
And we should just invite the students and other participants to ask questions in the chat.
Yes, please. The chat is wide open and you can chat to everybody or to me and Michael Huggins, please.
Hi, so I saw Stephanie Savage had a comment about a case that is scheduled to be heard in November in front of the Supreme Court. That case is Brownback v. King. And the underlying facts kind of give rise to a question of qualified immunity because the plaintiff in that case filed two claims initially. One was based on the Federal Tort Claims Act, and the second one was a Bivens complaint, which is very closely related to 1983 claims, but instead of sort of filing them against state actors, a Bivens claim is filed against federal actors. In any case, here's what happened in that case and why the Supreme Court's review of the case, the petition on cert, doesn't really get to the heart of those qualified immunity issues, but rather a sort of procedural one, right? So as I said, two claims are filed, right? That goes up to the district court. And at the district court, the government argued that the district court did not have subject matter jurisdiction over that Federal Tort Claims Act claim, right? So the district court sort of got rid of it there based on a lack of subject matter jurisdiction. Then the district court concluded that the Bivens claim that King had raised was barred by qualified immunity. On appeal to the Sixth Circuit did not address the Federal Tort Claims Act, but did say that the qualified immunity doctrine did not bar the Bivens claim, right? So of course the government petitioned for cert, and the Supreme Court has agreed to hear the Federal Tort Claims Act argument that the government is now raising. Now the government is not disputing the qualified immunity determination by the Sixth Circuit. What it is arguing is based on a section of the Federal Tort Claims Act, which is the judgment bar, right? And that judgment bar language provides that there is a complete bar to any action of the same subject matter. Or in other words, because the district court had eliminated the Federal Tort Claims Act initially based on lack of subject matter jurisdiction, the Bivens claim that King raises is barred by this judgment bar, right? I hope that's clear. So that's the question. That's the specific question in Brownback v. King that's in front of the Supreme Court, and we'll hear oral arguments in that in November.
So Professor Ricardo had mentioned Bivens. The court ruled on a really important Bivens case this past term that we haven't mentioned, but I think demands our attention. Bivens, it was Hernandez versus Mesa. This was the cross-border shooting case where a Border Patrol officer shot a Mexican youth in the culvert that runs between the US and Mexico border. He and his friends, the Mexican youth and his friends, were playing a game where they would run across the culvert and touch the other side of it, the US side of it, and then run back. And a Border Patrol officer biked up and started firing at these youth and killed the this individual. And his family brought suit under Bivens, which allows constitutional torts against federal officers for violations of the federal Constitution. The Supreme Court said that there is no Bivens remedy. Now, between tightening up the Bivens remedies, between tightening up 1983 claims, and between qualified immunity, what we're seeing is a kind of confluence in civil rights litigation where the court is making it more and more difficult to bring these claims. And, you know, I think that's a really distressing trend that we need to keep our eye on. But when we do it, we need to keep our eye not just on any piece of it, but how these pieces intersect. Professor Acevedo mentioned earlier the doctrine of standing. The Supreme Court also has tightened up standing requirements in recent years. And that's just another way of impeding access to courts to protect civil rights. And again, part of this larger trend of making it more and more difficult to get into federal court to protect civil rights. Do we have other questions?
I'll just add, Professor Schwinn, I think that's absolutely right. It's really important to pay attention to what's going on in the courts and the sort of quagmire that's at the courts right now based on, you know, these decades of jurisprudence building up the strength of the qualified immunity doctrine. But as I reminded my students earlier this week, we also need to be paying attention to what's happening at the political levels, what's going on at Congress, and pushing our elected representatives to address the problem if the court won't or if the court can't.
That's a really good point. And, you know, our own Senator Dick Durbin is a champion of a federal Bivens claim. and has looked carefully at these issues. For folks who are interested, I would urge you to check out some of the work that our very own senator from Illinois has done on the federal level in this regard. But there's way more to do, and we need to get a coalition together in Congress and a president in the White House who's willing to sign legislation to open up these kinds of claims. Just on that point, I wonder if I can ask my friends, what do y'all think about the nomination of Judge Amy Coney Barrett? Not all at once.
I think we all unmuted ourselves at the same time, though.
I'll dip my toe in the water here. I would very much prefer, without criticism, I would very much prefer to wait to see the results of the election. I think that would be the proper approach, and I'll leave it at that.
I think she's probably a lovely woman. And I think I was having lunch at the Union League Club, and I think I saw her just having lunch with a friend off in the distance after her meeting with Trump. But she doesn't have as much experience as Obama's nominee had, doesn't have as much judicial experience, and is being rushed through in much shorter time than the 293 days that President Obama's nominee had. What happens to the court long-term? I don't know. I'm reminded about a law review article that Justice Brennan wrote, I think in 1986, when he was urging people who were disappointed at that time in the US Supreme Court's decisions to take pay more attention to state courts. And Professor Ricardo's comment about this is also a political question that we need to look at Congress also reminds me that we're going to have to look at state courts as well as a forum for litigation.
I would say that the interesting question about this vacancy on the Supreme Court is what's happening sort of politically. And to all students of legal writing, I would urge you to pay attention to the very interesting ways in which our senators are distinguishing cases here. We had the same situation in 2016 when President Obama was trying to fill a Supreme Court vacancy with about 8 or 9 months left in his last term as president. We have this time around a much shorter gap here, and we had the Republican senators in 2016 saying they wouldn't do it because they wanted the people to vote. I want to call your attention, just for rhetorical purposes, to Senator Mitt Romney's statement on filling the Supreme Court vacancy. He says, and I think it's a very careful distinction he's making based on the facts, which is interesting to pay attention to. He says, the historical precedent of election year nominations is that the Senate generally does not confirm an opposing party's nominee, but does confirm a nominee of its own, which is, I think, a very interesting way to parse the issue.
Can I jump in and add one more comment? I think that we forget that the Supreme Court has limited original jurisdiction, and I think that there's a tool that Congress can use, and that's the exceptions and regulations clause in Article 3 to limit jurisdiction of the Supreme Court in certain matters. That's a possibility, and that would require further study, but I throw that out there for what it's worth.
And I'll just add, because I want us to get to the question that's in the chat, but first to express just the deep and profound sadness that we can't even mourn really properly for, nationally for a legal giant who was so intent on preserving our democracy that her dying wish was that we wait until the election. And I think that says a lot about, where she was in her mind. I wished for her that she could have, been with her family and friends and not at her passing and not have to think about us. But also I think we're in a crisis mode when we are depending on one person so heavily to affect change. Like that says to me, we're in a danger mode and our democracy is failing, our institutions are failing. And so I'll put in the chat here, there's a link to an article that I read recently, The Case for Abolishing the Supreme Court as We Know It. And it basically calls into question the Supreme Court as a neutral body. It is very much a political body. And so I think Ruth Bader Ginsburg's passing and Amy Coney Barrett's nomination really shows that in, writ large.
Thank you for sharing that, Professor McMurtry-Chubb. That's an outstanding article. The discussion, there are a couple of questions in the chat, and I've received some private questions about, what happens now? Can you stack the court? Well, yeah, the Democrats, if they were able to, if they had the votes in the House and the Senate and the White House, sure, they could stack the court. There's nothing in Article 3 of the Constitution that specifies the number of justices on the court, and indeed, historically speaking, we have had different numbers on the court, so they could do that. It could come at a political cost to them, or maybe a political benefit to them. And I imagine that's going to be the calculation that many are looking to after the election, if indeed Democrats retake the Senate and the White House. I wonder, do any of my other friends have anything to say on court packing?
I'm fascinated by the proposal to limit the Supreme Court justice terms to 18 years and to have a new justice appointed every 2 years. I think it's a very interesting idea, and I want to think about it a little bit more.
Yeah, and a lot of other democracies around the world do that. We're actually unusual in that we grant life tenure to our judges. Most rotate in some way and get the benefit of fresh thinking and diverse thinking on the court. And other countries do different selection processes as well. We have traditionally had our own selection process. The Trump administration has relied heavily on the Federalist Society, and the other countries, some states rely on judicial nomination commissions and practices like that to help mix things up a little bit and create ideological diversity and change at their court.
And even if the justices were limited to a term of 18 years, they'd still have really good retirement benefits.
Don't forget healthcare.
Yeah, exactly. Which we didn't talk about, but there is a big healthcare case challenging the ACA on the docket for November 10th. Rather than spending additional time here, I just put up a video on my YouTube channel. If anybody's interested in that, you can check it out. We're coming close to the hour. I do want to acknowledge one thing and thank Professor Wojcik for reminding me. Our own Professor McMurtry-Chubb was the recipient of the prestigious Blackwell Award from the Legal Writing Institute, and I think we ought to give her a round of applause and just acknowledge that.
Everyone put your screens on so she can see you applauding. This is a major award that she's won, and we're really tremendously proud of Professor Teri McMurtry-Chubb.
Thank you, everybody. And congratulations to my dear friend. It's just a reminder of how lucky I feel every day being a member of this faculty and having such dear friends and colleagues as those who joined us today. So I do want to thank the panel. It was an outstanding presentation. It was a real treat for me and an honor to be able to participate with you. And I want to thank the participants. I'm thrilled that we were able to top 60 in the participants for talking about something that, a lot of people might not really want to talk about so much, but this was just a fantastic discussion, excellent questions. I appreciate your participation. Panelists, again, thank you very much. And we'll have this, the video of this up in one way or another at some point in the future. So thank you all. Take care.